Hello dear student, very good evening to all. Today we are going to discuss about day 5 polity question answer. Let me give a small introduction about the daily answer writing program. Dear student, we have started this program from 1st of July and it will continue till mid February. We'll cover your entire syllabus, that is include GS1, GS2, GS3 and GS4. It also include the essay. ठीक है. So to participate in the daily answer writing, you can join our application or you can join our telegram channel that is already given in the link. ठीक है. You can also collect all this PDF of the model answer in the telegram as well as in application also. ठीक है. Dear student, let me give a small introduction about myself. Dear student, I have written 5 mains and 1 interview. So over a period of time I have gained a lot of insight of how to write a good answer. I have also committed a lot of mistake during my preparation. So I am putting all my experience knowledge to make this video series, that is from starting from the 1st of July till your February. Hope this is going to help you and make your it will overcome your fear towards answer writing. ठीक है. Let's start discussion regarding the questions. The question is right to get fundamental right itself is a fundamental right under the Constitution of India. ठीक है. जो आपका fundamental right है वो मतलब right to get फंडामेंटल राइट इटसेल्फ इज ए फंडामेंटल राइट. दैट मीन्स जो फंडामेंटल राइट है उसका प्रोटेक्शन होना ये भी एक फंडामेंटल राइट है. ठीक है. इन लाइट ऑफ अबव स्टेटमेंट डिस्कस हाउ आर्टिकल 32 constitutional right to constitutional remedy help in protection of the fundamental right. Okay. Dear student, I have already discussed about how to write a very good answer framework, like how to write introduction, body, conclusion. Please go to the first lecture and watch that. After that you can come back and watch this video. Okay, for better understanding. Okay. Now first thing should be first, after getting an answer, for example you get the question, like you have to write in 150 word and 10 marks in 7 minutes. So first thing you need to identify core demand of the question. First you have to identify the core demand of the question. What is the core demand? You have to address how right to get फंडामेंटल राइट इटसेल्फ इज ए फंडामेंटल राइट. मतलब आपका जो फंडामेंटल राइट है, जो राइट टू जो आपका फंडामेंटल राइट है वो उसका प्रोटेक्शन एक फंडामेंटल राइट है. ठीक है. जैसे मान लो राइट टू इक्वालिटी, ये तो हमें देता है राइट टू इक्वालिटी, बट अगर इन केस अगर राइट टू इक्वालिटी अगर मेरा वायलेट हो जाता है तो वो वायलेशन को प्रोटेक्शन जो होगा वो भी एक फंडामेंटल राइट है. ठीक है. सो क्वेश्चन इज टॉकिंग अबाउट राइट टू गेट फंडामेंटल राइट इटसेल्फ इज ए फंडामेंटल राइट. ठीक है. इन इंडिया, इन लाइट ऑफ अबव स्टेटमेंट डिस्कस हाउ आर्टिकल 32 राइट टू कॉन्स्टिट्यूशनल रेमेडीज हेल्प इन प्रोटेक्शन ऑफ द फंडामेंटल राइट. सो you need to keep in mind this statement, right to get fundamental right itself is a fundamental right. So you have to be right on your answer keeping in mind this statement. Okay. Then first part of your answer you need to address that statement, how the right to constitutional remedies help in protection of the fundamental right. ठीक है. So you need to first discuss about the article 32 right to constitutional remedies and its provision. Then you need to discuss how the right to constitutional remedies itself help in protection of your fundamental rights. ठीक है. This is the core demand of the questions. Let's start the introduction. In introduction you can use the article 32 of Indian Constitution, often referred to as the heart and soul of the Constitution. क्यों इसको हार्ट एंड सोल बोला जाता है? लिसन केयरफुली. देखो, जैसे एक ह्यूमन बॉडी, इन ए ह्यूमन बॉडी इट इज़ द हार्ट एंड सोल दैट इज मेक ए बॉडी लाइव. Same with Indian Constitution. If your article 32 in our Constitution is removed, then fundamental right will have no value. For example, if your right to freedom of speech expression is violated and there is no legal way you can enforce that. For example, कोई आपको मना कर रहा है कि आपका राइट टू फ्रीडम ऑफ स्पीच करने नहीं दे रहा है, तो आप किसके पास जाओगे? अगर जाके कोर्ट में या फिर कोई पुलिस के पास, ये अगर जाके आप जो प्रोटेक्शन अगर नहीं ले पाएंगे, फिर फंडामेंटल राइट टू फ्रीडम ऑफ स्पीच एक्सप्रेशन का मीनिंग क्या है? दैट इज़ द रीज़न दे आर कॉल्ड एज हार्ट एंड सोल ऑफ द कॉन्स्टिट्यूशन. ठीक है. दिस इज बिकॉज राइट टू एनफोर्स फंडामेंटल राइट इटसेल्फ इज ए फंडामेंटल राइट अंडर द कॉन्स्टिट्यूशन ऑफ इंडिया. ठीक है. दिस इज नॉट कोर डिमांड. देन वन मोर क्वेश्चन, डियर स्टूडेंट, यू कैन राइट इन द कमेंट व्हाट इज द डिफरेंस बिटवीन, you can write in the comment section, what is the difference between article 32 versus article 226, ठीक है. Both provide for the right to constitutional remedies. Please write what is the difference between Article 32 and Article 226, ठीक है. Let's discuss about the body of the answer. Right to get fundamental right itself is a fundamental right, ठीक है. The direct access to the Supreme Court. So in case under Article 32 provide the right to individual to move to the Supreme Court directly for enforcement of their fundamental rights. अगर आपका कोई भी फंडामेंटल राइट दैट गेट वायलेटेड, यू कैन डायरेक्टली मूव टू द सुप्रीम कोर्ट. नो नीड टू गो हायरार्की लाइक हाई कोर्ट देन सुप्रीम कोर्ट. You can directly go to the Supreme Court. That is the reason it is given as a right to get fundamental right itself is a fundamental right. Second is writ jurisdiction. Once you file a case in the Supreme Court, then Supreme Court issue writs. The writ jurisdiction of the Supreme Court under Article 32 is a fundamental aspect of the Constitution. That is the basic structure of the Constitutions, ensuring that individuals have a swept effective remedy to address the violation of their fundamental rights. So once you move a case or you move to the Supreme Court for your violation of the fundamental right, then Supreme Court issue writs in the form of habeas corpus, mandamus for enforcement of your fundamental right. And the nature of this writs are swept. दैट मीन्स ये बहुत फास्ट एंड रेमेडी होता है जो आपका फंडामेंटल राइट को प्रोटेक्ट करेगी, ठीक है. देन देयर फंडामेंटल नेचर. The Article 32 itself is considered as a fundamental right, ensuring that citizens have right to seek justice for enforcement of all other fundamental right, ठीक है. That means Article 32 itself is a fundamental right. That means so अगर आपका जो protection of the fundamental right itself is a fundamental right. That means in case of violation of the fundamental right, you can go to the Supreme Court for your enforcement of the fundamental right, ठीक है. Next part we will discuss right to constitutional remedy as a tool to protect the fundamental right, ठीक है. Right to constitutional remedy as a tool to protect the fundamental right. First is about the habeas corpus. What is the meaning of habeas corpus? You shall have the body. It's a writs issue to safeguard the individual freedom against the arbitrary and unlawful detentions, ठीक है. When issue, it compel the authority detain the individual to bring the person before the court and justify the detention. If court find the detention unlawful, it order the release of the individuals. This writs ensure the personal liberty is not violated without due process of law. For example, I am giving an example. For example, if a police person arrest a particular individual without having without committing any crime, illegally detain someone, then you can file a writs of habeas corpus in the Supreme Court. Then Supreme Court issue the habeas corpus to the police officer to produce the body before the court within 24 hours. And if Supreme Court find that the detention is illegal, then Supreme Court make that person free. Okay, so that is the reason. It help in real enforcement of your fundamental right. That means whenever your fundamental right get violated, there is a remedy. There is a remedy for you. So by writing every fundamental right in the Constitution is meaningless unless there is a enforcement for their violation. ठीक है. Then second is about the next writs that is issued by the Supreme Court is mandamus. The literally meaning of mandamus is we command. This writs issue to compel the public authority to perform a duty. ठीक है. This writs issue to a public authority to perform their duty that is legally obliged to perform, but it fails or refuses to do so. It ensures that public officials or body act according to the law, fulfill their duties. For example, if a government body fails to grant a license to the deserving applicant, a writs of mandamus can sought to compel the issuance of license, thus enforcing legal right. For example, if you apply a license in a municipality, but municipality is not issuing you the license, you can file a mandamus in the Supreme Court, and Supreme Court direct that authority to provide the license within a stipulated time. ठीक है. The next is about prohibitions. ठीक है. The writs issue by a higher court to a lower court or a tribunal directing the seize proceeding in cases where there is no jurisdictions. ठीक है. This writs prevent the lower court from exceeding their jurisdiction and ensure that they act within their legal bound. For instance, if a lower court attempt to hear a case that is within the exclusive jurisdiction of higher court, the writs of prohibition can issue to stop the lower court proceeding. For example, if a district court or any tribunal, let's say tribunal on the environmental NGT, National Green Tribunal, venturing into a domain that is not in their power, so in that case the higher court, Supreme Court, can issue a direction of issue a writs of prohibitions to prevent them moving beyond their jurisdictions. Okay? The next is about the certiorari. The literal meaning of certiorari is to inform. It is a writs issued by higher court to review and potentially nullify the decision of a lower court or a tribunal that acted beyond its jurisdiction or violate the principle of natural justice. Okay? The higher court call for record of the lower court proceeding. If irregularity are found, quash the decisions. Quash means make decision invalid. Okay? This writs ensure justice is administered in a fair within the bound of law. Okay? For example, if a lower court give a penalty, death penalty, on a frivolous ground without considering the fact, then higher court can review the cases. He found that the cases or the death penalty given without having any substantial matter, then it can even reject that penalty. Okay? That is the certiorari. The next is about quo warranto. The meaning of quo warranto is by what authority. This writs issue to challenge the legality of a person claim to hold public office. For example, if someone is holding a public office, so you can challenge legally. Okay? It requires the individual to demonstrate the authority under which they occupy position. If the person fails to justify their claim, the court can declare office vacant. This writs help preventing unlawful occupation of public offices, ensure that only qualified and legally appointed individual hold such position. For example, if there is an appointment of any government office, an official is appointed, but proper procedure, proper qualification is not followed, then in that case you can file the quo warranto and Supreme Court consider a case. If there is a merit, then Supreme Court direct to vacate that person from the position. Okay? This is all about your body. You have discussed, you have linked all the 5 writs with how it protecting the fundamental rights of the individuals. So that is the core demand of the questions. After meeting the core demand of the question, you need to write a good conclusions. Okay? In conclusion, you can write Article 32 design as the heart and soul of the Indian Constitution, highlighting its crucial role in protection and enforcement of the fundamental right. By providing a direct remedy for right violation, it ensures that constitutional guarantees are meaningful and effective, maintaining the rule of law and supremacy of the constitution. अगर मान लीजिए you have only the fundamental right but there is no enforcement, then there is no meaning. For example, you have right to equality but no one is respecting. For example, there is a widespread participation of untouchability, then there is no meaning of right to equality. But when there is a enforcement, or when there is a right to equality itself, like fundamental right itself is a fundamental right, in that case you get the opportunity to enforce that right to equality. In case of violation of right to equality, you can move to the Supreme Court for enforcement. Okay? ठीक है? That is all about today model answer of day 5 polity questions. Dear student, for more video you can subscribe to our channel and please comment on the comment box what kind of video you want in future. And in case of any doubt, you can also comment. Please do join our application and the Telegram channel. So keep in contact with us. Bye bye. Thank you.